a snowy Thursday evening, and we're anticipating the Supreme Court of Canada's decision, which is going to be handed down tomorrow morning. We're anxious. I'm anxious, I'm nervous, and I've always thought that, well, I guess I've always thought we were going to win this case, but I just don't know if we will. So we filed our lawsuit in 2011.
I was talking to Joe, and we were just talking about physician-assisted dying, and I'm sure part of what I was going on about was how much I hate the Rodriguez decision.
I was pretty young at that time, and then I remember studying it in law school.
At the time, I thought it was the wrong decision. Reflecting back now, I understand the decision, but I always thought it was a case that needed to be relitigated one day.
Shortly after we filed our lawsuit, we were contacted by Gloria Taylor. And she said, I read about your lawsuit. This issue is so important to me. How can I help?
Well, the current law is a complete and absolute criminal prohibition. So there's a blanket prohibition against assistance or helping someone die, and that's whether or not it's a physician, whether or not the person is suffering, and whether or not it's medical treatment.
On its face, it's a very compelling argument that a law that prevents people from dying is a good law, because on its face you think it's going to save lives. What could be a more important law than that? We find out that this law that purports to save lives actually kills people.
A person like Gloria, who knows that she is slowly losing the ability to use her body. If she waited too long, she would no longer be physically capable of taking her own life. She wouldn't be able to open a jar of pills. She wouldn't be able to raise a gun to her head.
The only time they can end their life without assistance is when they still want to live.
So it's still beneficial life that they still want to live. And they're saying, I'm going to kill myself now because the law won't let anybody assist me later.
I don't have privacy, I don't have any independence. I need help with all activities of daily living, like eating, brushing my teeth, going to the bathroom. My greatest fear is to be suffering and not have an end to it.
A lot of evidence from people who said, you know, living in the conditions that I'm living in is a fate worse than death. And so I saw through the evidence in this case that there are fates worse than death.
If they wait that long to the point where their life is actually worse than death, they're unable to end their life without assistance.
There is no law against suicide. So if I were suffering intolerably and I wanted to end my life as a response to that medical condition, I'm completely entitled to.
How does it make sense that if I'm able-bodied, I can kill myself in any way I want to? And if I'm not able-bodied, that I can't do anything?
It would be patronizing for us to tell those people that they should just adapt and cope with their disability.
No one is allowed to have assistance, but the burden is unfair on those who actually need it because of a disability.
And I don't think that the risk of a floodgates is real enough to impose that burden on that group of people.
Lee and Hollis assisted Lee's elderly mother to travel to Switzerland to have an assisted death.
Her health was deteriorating fairly quickly, and she said, I'm done. I'd like to move on, and it should be my choice.
There was a risk of prosecution, there was a risk of being found out.
We had to lie to the care facility, which really bothered her a great deal because she couldn't say goodbye. And it bothered us because I don't like to lie.
Well, since the Supreme Court of Canada last heard Sue Rodriguez's plea to change the law, there has been a sea change in social thinking around the world.
So when we brought this case forward, we had not only the evidence of Gloria Taylor, but we also had all this evidence from all these other jurisdictions, places like Oregon and Washington and the Netherlands and Belgium.
The trial court in the Rodriguez case only heard the voice of Sue Rodriguez, but we had the benefit of the research of social scientists who had studied those systems to see how they were working and if they were working well.
Well, I think at the heart of this case there's sort of two principles, and it's autonomy on the one hand and it's kind of mercy on the other. What I think this case is about is people's ability to make sort of fundamentally important personal choices about health care at the end of life, or in circumstances where they're suffering intolerably and maybe they're not at the end of their life. So it's about affording the dignity of choice to these people. And as a society, I think that's a merciful thing to do.
I think it's fundamentally incompatible with life to tell someone they have to live it. I think it's fundamentally incompatible with what we should understand to be life, for one of the qualities of that life to be involuntary. And that you can't capture people in life and you can't force people to live. And it's certainly not the government's job.
What happened? Well, in this case, there was a lockup. The judgment came down, and we went to court, and we were sort of in this room down in the basement of the court.
It's offered to all sides and interveners, and I think the only people who'd agreed to go to the courthouse were Joe and Alison and Grace and I.
What Madam Justice Smith did is she struck down the laws that criminalize physician-assisted dying, and she found that there were violations of Section 7, the right to life, liberty, and security of the person, and that the laws also violated the Section 15 equality rights.
One of the things, and I'll always remember this about Madam Justice Smith, and if I ever become a judge, I will always remember it. Because in lots of decisions, you have to get to the end to find out what the answer is, and she put it in the first paragraph.
We were elated. We were beyond elated. We won on every single point. It had been such a tough fight.
We hoped that at that point that Canada would sort of see the light and read the judgment. It was so carefully reasoned, and say, hey, we've got a problem here, and maybe we're gonna take this judgment and fix this law. But they didn't, and they appealed, and so we knew we had to carry on with the fight moving forward.
The BC Court of Appeal handed down a decision today on a landmark right-to-die case.
BC's Court of Appeal has upheld Canada's ban on doctor-assisted suicide in a 2-1 split decision.
So the BC Court of Appeal basically said its hands were tied, and that the issue, if it was going to be revisited, would have to be revisited by the Supreme Court of Canada.
Much of our team from BCCLA has come from British Columbia out here to Ottawa. Well, Grace Pastine, who's our litigation director, is here. She has been shepherding this case from the very beginning, along with the pro bono counsel working for us. Of course, Lee Carter and Hollis Johnson are here, who are plaintiffs in the case, and a number of members of their family. The reason why we have so many staff here, we're the ones who've brought this case forward along with the families. So we do feel we have a special obligation. It's important to be able to communicate both with Canadians broadly through the media and also to our supporters about what this means.
It was incredible to go to the Supreme Court. I have so much regard for the justices on that court, and this was such a special case to bring there with this legal team.
This is a momentous occasion.
You would get nervous anyway, frankly, because it's a big enough stage. But then if you add on all the responsibility of it and the idea that if you did it wrong, that people might be out there suffering because you did it wrong. And by the time you've layered all the things you've taken on, by the time you want to go to stand up, it's a very intimidating thing.
Well, our adversary in this case is the federal government. There were 3 lawyers working on this case for us, who are working completely pro bono, whereas the federal government has virtually unlimited resources at hand. So it was really a battle of David and Goliath proportions.
It will be one of the most significant decisions in the Supreme Court's history. Tomorrow, it will decide whether Canadians should have the constitutional right to control the way they die.
Many Canadians remember the Rodriguez case, and it's been sort of sitting with society for this long period of time. It's nerve-wracking. I know that our lawyers who argued the case, who've poured so much of their hearts, their time, their thinking, their emotions, their preoccupation for years been poured into this.
So I'm very grateful to the BC Civil Liberties and to the lawyers and all the other people who have come forward to support this case. And that just doesn't mean it's not just us guys, but it's a lot of other people that have spoken.
Mm-hmm. Right now, it is very overwhelming for me to think about all of those contributions to this case, and I feel a real responsibility.
It was a pretty late night, so I'm pretty nervous. It's very strange this morning. All of the work in the last 4 years just comes down to flipping the page to the page that says whether or not we won or lost.
Okay, you guys.
I know.
Start walking.
We won. Unanimous. We got everything.
Wow!
I think we're taking Elayne and Alison and the family down first, and then Josh and the others.
Good morning. We won unanimously. We won on everything.
The full victory, signed by every member of the court. And
if Elayne is there,
congratulations to you, Elayne, for all of the work that you've put in on this case.
We're all thinking of you here. Thank you. Now we've got to get some press releases out, so I'm going to get off the phone, but we'll talk soon, I'm sure.
I thought we'd win. I didn't think I'd cry. Because I haven't.
This is a tremendous victory for human rights and for compassion at the end of life. What this decision means is that Canadians who are suffering unbearably at the end of life will have a choice now.
A huge victory for Canadians and a legacy for Kay. Thank you. Thank you.
All the messages, actually that's what I was looking on my phone, all the messages started coming in and people saying, you know, I just saw it on the news and my mom's name will be in the history books now.
This is hugely meaningful for the BC Civil Liberties Association. This is really the largest fight that we've done in our 53-year history.
It's really important in a case like this to have an institutional plaintiff. The reason for that is because at issue in the case are grievously ill people who could die during the course of the litigation, and we had that experience during this case. But also, it's a lot to ask of a person at the end of their life to take on the burden of major litigation.
Well, you can see how people fell in and out, right? You can't really hold something this big and fluid together without some sort of backbone to it. We knew that people would come forward and say, include my story too, include my story. I don't know if those same people would have come forward if we hadn't also been the Civil Liberties Association.
I think we're one of the very few organizations in Canada that can litigate cases of this complexity from trial up to the highest levels of court.
The issues that arise in constitutional cases are, usually pretty fascinating for everybody.
Do I like doing this? I love doing this. I've never done anything more worthwhile, and I doubt I ever will. Sheila Tucker. I was co-counsel in Carter with Joe Arvay and Alison Latimer.
Grace Castine, and I'm the litigation director for the BC Civil Liberties Association.
My name is Alison Latimer, and I'm a lawyer at Ferris & Company.
My name is Josh Patterson. I'm the executive director of the BC Civil Liberties Association.
I'm Joe Arvay. I'm the lead counsel in the Carter matter.